Welcome to Family Law War Room with Brad LaMorgese.
Hello, everyone, and welcome back to Family Law War Room with Brad LaMorgese. Brad's a board-certified family law attorney in Texas who specializes in high-stakes divorce, complex property division, jurisdiction disputes, and family law appeals. I'm Sean O'Connor, and today Brad and I are talking about dividing businesses and high-value assets in a Texas divorce. Brad, good to see you.
Good to see you, Sean.
I mean, this is your sandbox, the high net worth divorce sector, if that's the right word. But I'm wondering, why do business ownership interests and high value assets create a complexity, or not a complexity, but like a completely different level of complexity in certain Texas divorce cases?
That's definitely true because you're no longer just dividing property, you're analyzing systems. In a typical divorce, you're dealing with things
Hmm.
like bank accounts, retirement, maybe a home. In high asset cases, you're typically dealing with operating businesses, even layered entities, cash flow structures, and assets that are constantly changing in value. But there's also an issue of
Huh.
characterization. And in Texas, we're dealing with separate versus community property. When a business exists before marriage and grows during marriage, that growth has to be analyzed very carefully. And what portion is attributable to the time, effort, and potentially community
Well,
investment versus what remains separate. And then you can add liquidity because the
hmm
assets aren't always easily divided. You can't just split a closely held business without even potentially destroying it. So you're dealing with valuation, buyouts, structured settlements, and things that require typically very deliberate planning.
we're talking about uh, valuation, and it can be a kind of moving target. Um, where do these valuation fights usually become the most contentious in your experience?
Well, usually each party will have a forensic accountant who's they do valuations, and
Hmm.
it is almost always one of the central battlegrounds that somebody's trying to get a value up or get it down. There are different ways to value a business. So there's three approaches: the income, market, and asset approach, and each can produce very different results on how it's applied. You
Hmm.
also see disagreements over things like projected earnings, appropriate discount rates, and whether certain expenses are legitimate business expenses or discretionary spending that should be added back. And in privately held businesses, there's often no market to price it. So the valuation becomes a combination of financial data and expert judgment. And that's where the fight is. One
Yeah.
side, again, is maybe arguing for a lower value, one side's arguing for a higher value, or the parties may be both wanting stock, depending on if they were operative business owners.
Yeah, it's interesting. It's like they're arguing over acceptable accounting practices, so to speak, right? Like, and there just are different ways in which businesses are valued outside of any divorce situation, and just in terms of, public companies and all that. We see in the news all the time how they're we basing it on sales, views, customers, transaction. So much. There's so many variables there. I can see how it can get a little dicey. How do courts analyze situations where, let's say you mentioned this, Brad, the business exists before the marriage, right? But post marriage, or I mean, and during the marriage, rather, the value increased substantially. So are they like, okay, do you need to make sure that you lock a value at time of marriage, so to speak, for the record? How do they deal with that?
It's pretty interesting in Texas because that's an intersection of your financial analysis and your characterization.
Mm.
Generally, if a business is started before the marriage and there's really been no change, even if it grows tremendously, it's still separate property. If a spouse puts a lot of effort into it and essentially deprives the community of an estate, that is something a court would look at as, okay, what, we don't have anything to show for this community. Now, typically, without a prenup, the income earned from a business is frequently going to be community property, so that may balance
Mhm.
it out. But you're looking at typically is if there's passive factors like market forces, it's almost always going to just retain its character. For instance, if I had
Okay.
bought 10 shares of Apple stock in the beginning, that would have been a
Yeah.
great thing. And that increase in value just keeps the separate character. But if the community contributed growth or time or labor or management, that can be a claim for what's called reimbursement.
Hmm.
And you'll also see claims, nuanced claims for if there's income generated and then all of a sudden it starts being retained inside the business instead of distributed, that may raise some character claims with, the income should have been distributed.
Like potentially 12 months before the divorce, or yeah, I mean, there's timing issues there potentially where all of a sudden,
That's not unheard of where all of a sudden return and, earnings start getting retained when, divorce is in the air.
well, and also in the case of, a business, I come into a marriage, I've been running a business, but I'm guessing that if, oh, my wife ended up taking helping with the books, let's say, doing, took, became employed basically, right? Would be the simple answer. That would then shift. That's community involvement in this context. Yes.
Potentially would be community reimbursement to the extent the spouse was not adequately compensated. If they were just putting in effort to help the other spouse, then probably there's a reimbursement claim there.
Well, that's it. Yeah. And so, but if they were paid like, hey, Betty, I want you to work for the company and you're going to be paid a salary, then that would probably do away with there's not going to be reimbursed for you.
Yeah, there may not be a reimbursement claim if somebody was adequately compensated.
What kinds of asset structures or financial arrangements tend to create the most disagreement during, the property division litigation?
I think the most contentious cases involve what I would call layered or opaque structures. So, for example, multiple entities, LLCs, partnerships, or holding companies
Mhm.
that are interconnected. Those structures can make it difficult to trace ownership, income flow, and actual value. You also see disagreement around assets that don't have a regular, predictable cash flow. And those things may have carried interest, private equity investments, or complex compensation structures tied to performance. Another major issue all the time we're dealing with is commingling in Texas. When separate and community
Mm.
funds are mixed, or when business and personal expenses overlap, it's harder to draw those clear lines. And so those will create the accountants to have to go to work or looking at deep into those documents. And from a litigation standpoint, the more complex the structure, the more room there is for competing interpretations, and that's where disputes tend to intensify.
Well, you had mentioned, a couple of moments ago, like, oh, it appears retained earnings suddenly became more of a, or began to increase at a particular date. I'm wondering how allegations involving, say, hidden income or understating the business value or even incomplete financial disclosures would change the direction that a divorce case would go. I mean, I'm assuming a judge is gonna look at that quite negatively.
Well, those allegations are a real curveball. They can definitely change the trajectory of the case. When one party
Mhm.
believes income is being hidden or value is understated, which in a divorce, there's frequently trust issues amongst the spouses on
Right.
did they tell the truth to me? And so the case often shifts into a more aggressive discovery phase, asking the questions that
Mhm.
need to be asked, getting the documents that need to be obtained, and analyzing those records in detail, potentially issuing subpoenas to third party, providers, and often bringing in experts to reconstruct that financial activity. It also affects
Mhm.
credibility. So if a court in particular begins to question the accuracy or completeness of one side or the other, that can become a real issue, even if something has gone on or not gone on with the estate. And so those claims, I always say, turn it more into an exotic case, which means is driving up the costs, the complexity, and the
Mm.
amount of diligence that needs to be done. And if somebody really is understating or doing something nefarious, they are going to make it as difficult as possible to get a hold of documents, to get people to testify. They don't want to give up that, what they've understated, if that's really true, or if they're masking assets. Frequently you'll see, oh, well, we sold that to my family, or something like that at a very low cost. So those are
Yeah.
technical and contentious.
Well, and so, in those situations, right? And so now we've got, we've got the forensic accountants and we've got the valuation experts and, we've got financial trade, they're trying on, it's these things are made complicated to make it difficult to make it opaque, right? Um, does each side hire their own, well, or, like who's hiring these people and who's paying them?
Each party would typically hire an expert, and that's really guided by the lawyers, but it would be a forensic accounting, and you'll see lots of really, really good ones work in this field. They're very familiar with the legal concepts. I think frequently we talked about it a little bit, but valuation experts are critical when you're dealing with operating businesses, but they're also analyzing the financial data, applying these valuation methodologies and explaining those conclusions to the court. Those same forensic accountants also come into play when you're looking at questions about income, expenses, financial accuracy.
Mm.
And then one of the most important things in Texas in particular, because we do have separate property, and separate property is in fact a constitutional right, those accountants will also be tracing experts that look at when was title established, or in looking at this account, what assets accumulated in it were income, which would typically be community during the marriage. What were corpus of things owned before the
Mhm.
marriage or maybe inherited? And they're looking at line by line, statement by statement, which what percentage is separate and what percentage is community. And in many cases, the experts aren't just supporting players, they're effectively become a huge part of the case to help the court understand the case, but also to help the lawyers who are not typically accounting experts or valuing asset experts, even though I think
Right.
your seasoned lawyers will very much understand those concepts. But they become key players.
Yeah. I mean, I know you've seen a lot of this and you understand it, but of course there's always something to learn. And that's why, someone hires you for your expertise, you're going to hire someone for theirs, especially when so much is at stake. And uh, we're talking about complexity and businesses, and I'm wondering, um, things like partnership agreements or ownership restrictions or multi-owner businesses, right? It's got to be complicate the property division negotiation process, right? I mean, what have you seen there? Is it just is it cut and dried or is it complicated? Yeah.
I think it could do both. It can complicate
It
and it can
depends.
simplify. It sounds like a typical lawyer answer, I know, but um, it depends. So in many closely held businesses, there are partnership agreements or operating agreements that restrict transfers of ownership, and that's definitely going to affect value, as like a lack of marketability or lack of control. Discounts get applied. You may have provisions that prevent a spouse from being an owner, so transfer restrictions, or things that would require approval from other partners. There may also be buy sell agreements that
Mm.
dictate how an ownership interest can be valued or transferred. And those agreements can actually override what might otherwise seem like a straightforward decision. So in multi-owner businesses, like you mentioned, there's a practical reality is you can't force other partners to accept a new owner, and you don't want the divorce to disrupt the business. Generally, that's not good for anybody. So instead of dividing the interest directly, you're often negotiating around it, potentially structuring buyouts, offsets, or even payment plans that account for those restrictions.
Yeah, like you may be entitled to a piece of that, but that number will be, you're not gonna be an owner, but we'll pay you out to some degree. Yeah, interesting. What about, I mean, in your sort of portfolio or even in the, in the realm that you work in, right? Is there an example of a high asset property dispute that that kind of demonstrates how sophisticated cases can become behind the scenes?
100%. So, without getting into specifics, obviously, I've
Yeah.
handled several cases, many cases actually, where there could be a single business interest that was actually a part of a larger network with multiple entities, layered ownership, income flowing through different channels, and one spouse might be a guarantor of many loans personally that support these businesses. So a lot of sometimes the spouse will see, wow, there's a lot of value here, but you can't just take out cash from outside of a business. The courts don't deal with businesses that way. They literally, the parties own the business interest. They don't own the assets inside the business, absent something extraordinary. So those can get very complicated because there can be a very high value estate, but it can also be illiquid, and it gets into the complexity of there's a cost of running a business empire, of being a billionaire, of being a mogul, that you typically just don't say, well, it's going to be 50-50, or we're going to split this equally, because there's not an equal partner necessarily. And so those cases typically are, you have a little bit of a luxury, literally, that whatever each spouse is going to recover from that case is probably going to suit them easily for a lifetime. But
Yeah.
it gets complex, and people want their fair share, and that's all very relative when you have complex business issues.
Yeah. 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 And then human emotions, uh, that certainly comes into play. Um, in the, in these complex property division cases, what have you seen in terms of, different factors that are going to, determine whether the dispute moves toward, sort of a practical, amicable type resolution versus something that's going to result in prolonged litigation? Are there red flags, so to speak, that you see?
Yeah, it's super interesting. That's a great question, because I've had smaller asset cases that cost a bunch of money, and I've had billionaires who were, we had clarity, credibility, practicality early. I think
Hmm.
cases move to a resolution when both sides have a clear understanding of the asset structure, the valuation, documents are produced, the cards are on the table, and everyone knows what they're dealing with. I think they stretch out when there's gray areas, when people are fighting tooth and nail over every little thing. And as you mentioned, emotions can really, help or hurt a case
Yeah.
to try to get it settled. But I think the best cases that get settled are the ones everyone knows you're not afraid to go to trial. You're
Hmm.
completely prepared. You know the insides and out of the case, and all the cards are on the table. The legal theories are exposed. The experts' opinions are well vetted, and then I think everybody can come to a clear understanding of the strengths and the weaknesses of a case. And then getting a great mediator who understands complex litigation or complex assets is also super key, because not every mediator is going to be dealing with cases like that. So we're
Yeah.
typically
Fritz.
seeing some specialist mediators as well.
That makes sense. That makes sense. Well, that's great, Brad. We're up against time, so I hate to close things off in haste, but I know we'll talk again. Thanks again for connecting and for sharing your expertise.
Thank you.
That's it for today's episode of Family Law War Room with Brad LaMorgese. To learn more about Brad and his work in complex family law matters, visit his website, lamorgesefamilylaw.com. Thanks for listening, and don't forget to like, leave a review, and share this episode with someone in your world who might need it. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.